Hi, good evening everyone. So my name is Jatin and some of you may be knowing me from teaching polity as a subject, internal security, governance, ethics. And today we'll be discussing about political science, international relations as an optional. And in PSIR specifically, we will be focusing on some of the topics that are at the intersection of polity and PSIR. The idea will be to introduce you to how one can approach PSIR with whatever knowledge that we accumulate while we are preparing for general studies too, as a part of our preparation for the exam. So that's why I have named this particular session as from articles to arguments. While we are studying GS2, general studies 2, we generally tend to focus on the articles, the content of what those articles essentially mean. We possibly go into some of the cases as well. But in this particular session, we are not just going to be focusing on the articles or the content, but we will try to understand that how we can use that particular knowledge and then build on it for preparation for PSIR as an optional as well. So before we get into the thick of the things, I want to talk about this particular date, that is 24th of April 1973, a very significant date in India's history. One, of course, for the reason that this was the date the judgment in the Keshavananda Bharti case was pronounced by the Supreme Court of India. 68 days is what it took for the Supreme Court of India, 13 judges, perhaps the largest bench that has been formed in India's constitutional history, which has decided a case. There was another bench which was consisting of 15 judges which had been formed after Keshavananda Bharti case, but it never really gave any particular judgment. So this till date remains to be the largest bench of the Supreme Court of India that has given verdict on any particular issue. And perhaps one of the most important judgments of the Supreme Court of India as well. It is often said that it's a case that saved India's democracy, and we'll understand why. Now, in this particular case, the question that was there in front of the court was that whether the 25th, 26th, 29th constitutional amendment, 24th, 25th, 26th, 29th, these four constitutional amendments that have been enacted by the Indian Parliament, whether they are constitutionally valid or not. At the heart of the case was one of the rights related to the properties of a mutt in Kerala. So one of the mutt adhipatis of Kerala, that is Keshavananda Bharti, had approached the court that the Kerala Land Reforms Act, a legislation that was enacted by the Kerala state legislature, which had been put into Schedule 9 of the Indian Constitution via a constitutional amendment act, was unconstitutional because it took away the basic rights of this particular individual, including Article 14, Article 25, that is right to freedom of religion, Article 26, which is right to freedom of religion, but given not to an individual but to a community. And it was also against the right to property, which had been guaranteed originally in our constitution. The case, even though it related and initially it came up in the court with respect to the land rights or the property rights of a particular religious institution, but it ended up becoming a case which also ended up deciding the relationship between the parliament and the judiciary in India. What are the limitations on the powers of the parliament to amend the constitution? To what extent can the Parliament of India go to amend the constitution? Are there any limitations that have been imposed by the constitution itself? Are there any implied limitations within the constitution on the powers of the parliament? What is the relationship between Article 13 and Article 368 of the constitution? These were some of the questions that the Supreme Court delved deeper into in this particular case. And in front of the court were some of the most eminent lawyers, some of the most eminent advocates, those who were arguing in front of this particular bench of the court, and one amongst them was Nani Palkhiwala, who is said to be perhaps the most eminent, perhaps the most erudite advocate who may have ever walked into the alleys of the Supreme Court of India. So the judgment that was given in this particular case, as you all would know, was given 7:6. 7 of the judges of the Supreme Court of India held that Parliament of India does not have an unlimited power to amend the Constitution of India. The Parliament can amend any particular part of the Constitution, including the fundamental rights, but there is a certain restriction that shall be there on the powers of the Parliament to amend the Constitution, and that restriction is that whenever any amendment is made to the Indian Constitution by the Parliament of India, it should not affect some of the basic values that form a part of the basic structure of the Indian Constitution. What exactly the basic structure of the Constitution is? We can understand it this way, that it essentially means there are certain principles, there are certain ideas which are imbibed in our Constitution by the Constitution makers. Come whatever may, whatever changes that we may make in the Constitution, these certain basic principles of the Constitution should not get affected. It's similar to a building. So if there is a building that has been gifted to you by your ancestors, by your parents, by your grandparents, they tell you that you may change whatever you want to as far as the internal structure of the building is concerned. You may change the color of the walls, you may change where the kitchen is, you may expand the size of the room, you may bring down a particular wall, you may include certain part of a balcony inside the house, or you may make certain modifications in where the bathroom is, what the color of the tiles in the bathroom is going to be, but the basic structure of the house is not going to change. The basic foundation of the house, the pillars of the house on the basis of which the house is standing, that cannot be changed while you go about renovating the entire house from within. And that is exactly what the basic structure of the Constitution is, or the doctrine of basic structure of the Constitution is. A very interesting example that was given by a judge in the bench, who was sitting at the bench of the Supreme Court of India in this particular matter, was that the basic structure of the Constitution is very similar to the core principles of any religion. The judge equated the Constitution to the religion. He said that similar to a religion, where there are certain basic tenets of a religion which cannot be changed, which do not change over a long period of time, the Constitution of India also stands on basis of certain principles of the Constitution. They cannot be changed. The peripheral ideas can be changed. A very simple example that I often quote in my classes to the students is that one of the most basic principles that exists in Hinduism as a religion for solemnizing a marriage between a man and a woman is that they have to take 7 rounds around the pious fire. This is also called as the practice of Saptapadi in Hinduism. Until unless this practice of Saptapadi is completed, no Hindu marriage is considered to be solemnized between a man and a woman. Now, the way in which this exercise or practice of Saptapadi is conducted, it may differ from one particular community to the other. In some communities, you may see that the first 4 feras out of these 7, the man is at the front, and then in the next 3 the woman is at the front, and then vice versa in certain other communities. Today, with the advent of internet and with the advent of the information communication technology, especially during COVID, we witnessed some of the marriages or the wedding ceremonies, including the Saptapadi, happening virtually, where the priest was not necessarily present while the marriage or the wedding ceremony was taking place, because it was not possible for the priest or any of the individuals to travel during the COVID-19 lockdown. So while the priest was sitting thousands of kilometers away on a Zoom call and was chanting the mantras, the couple was taking the feras or was involved in the exercise of Saptapadi thousands of kilometers away on a Zoom call. The basic idea of Saptapadi has not changed. What has changed is the principles, the peripheral ideas around how Saptapadi is performed. Similar way, if we look at the Constitution of India as well, Constitution of India also has certain basic principles which the Supreme Court of India, through its judgments over the last 50 years or so, has claimed to be a part of the basic structure of the Constitution, which includes principles like parliamentary democracy, rule of law, the idea of secularism, the idea of independence of judiciary, the idea of the fundamental rights being subject to certain kind of limitations, and a number of other ideas that have been espoused by the Supreme Court of India to be a part of the basic structure. A lot of other things around the Constitution have changed. We have introduced tribunals in India, we have introduced various mechanisms that are different from what the constitution makers may have thought with respect to the appointment of the judges in India, or with respect to the immunities and the privileges of the parliamentarian, or with respect to whether a particular person after getting elected to the parliament can change his political party or not. But some of the most basic principles, which is free and fair elections, or secularism, or independence of judiciary, or parliamentary democracy, these principles have not changed. And this is what the doctrine of basic structure of the Indian Constitution is all about. Now, why am I telling you about this particular case when all of you already know about it? This case is just an example of what I want to show, of what you know when you prepare for doctrine of basic structure while you are preparing for general studies, and what is that is required for you to take your preparation to the next level if you are someone who's desirous of taking PSIR as an optional. Okay. Now, the point that I'm basically trying to make here is that almost all of you know what doctrine of basic structure of the Constitution is. Almost all of you would be able to tell that it was in Keshwananda Bharti case that this particular doctrine was pronounced by the Supreme Court of India. You would be also able to explain what are some of the principles that are part of basic structure of the Constitution. You would even be able to explain how this particular doctrine has helped in some ways in preserving India's democracy. But a PSIR student needs to answer the following questions, and I'll write them down on the board so that you understand what is the difference in approach as far as PSIR as an optional and preparing for polity via general studies is concerned. So, if I say that the topic is doctrine of basic structure, okay. So the topic is doctrine of basic structure of the Constitution. All of you know what doctrine of basic structure is. All of you know what are the principles that are part of the doctrine of basic structure, the case in which this was given by the Supreme Court of India. What are some of the benefits, or what are some of the arguments that have been given in favor of doctrine of basic structure of the Constitution. But let's say in this particular topic, when I deal with it from the perspective of PSIR as an optional, what are the things that I should be able to answer while I am responding to the questions, or what are the kind of questions that I need to be ready for? One of the questions that I need to be ready for is that, let's say, is doctrine of basic structure undemocratic in nature? Is it something that goes against the ethos of a democracy? If there is a parliament that has been duly elected by the citizens of India with a clear majority, and if it goes ahead and makes an amendment to the Constitution, that too with a special majority that requires the support of at least 2/3 of the members of the parliament present and voting, and also the additional condition of that the majority of the total membership of the House must also be supporting that particular amendment, can we still go ahead and declare any particular amendment made to the Constitution as Supreme Court of India as unconstitutional? Is it therefore not going against the very ethos, the very basis of democracy? Is the first question that we need to be able to answer when we say that and the question that arises is that, is doctrine of basic structure pronounced by the Supreme Court of India in Keshwananda Bharti case undemocratic in nature? Let's say if the other question that is asked by UPSC from this could be that, was the doctrine implicit in the Constitution of India itself, or was it made by the efforts of Supreme Court of India? In other words, was the doctrine already there and the Supreme Court of India merely discovered the existence of this particular doctrine, or was it something that was built brick by the Supreme Court of India? Now, to answer these particular questions, your basic understanding and knowledge of doctrine or basic structure is going to be useful. But you need to build on top of that as well, with the help of arguments from different scholars, with the help of arguments that were made in the Constituent Assembly of India, what were the things that was said in the Supreme Court, inside the Supreme Court, perhaps by the advocates, or the judgments that were given by the judges of the Supreme Court of India, and what are some of the contemporary scholars of political science speaking or talking on this particular matter. That is what is going to make you be able to write an answer to this question in a very specific manner that would be able to fetch you marks in the exam. Third question could be, if I have to ask you that, can you name a scholar and a case and relate both of them? When I am talking of a scholar, I am talking of some political science thinker or a scholar. It could be someone like a Madhav Khosla, or it could be a Pratap Bhanu Mehta, it could be a Granville Austin, it could be Neerja Gopal, it could be Devesh Kapoor, anyone. The point being that, can you name a scholar and a case that relates both of them and explains the basis of doctrine of basic structure? The difference, what I am basically trying to highlight here between PSIR and polity is this, that in polity as a subject, when I am studying it for general studies, as I said, when I talk about doctrine of basic structure in polity as a subject, I would understand what is it, I would understand what it includes, I would possibly have some advantages, possibly some criticisms as well. I would know some of the court judgments related to it, and that's where I would end it. Political science international relations requires me to go into questions like these. It does not want me to stop at just understanding what it is, or what are the principles that are part of doctrine of basic structure, or what are some of the court cases relating to doctrine of basic structure of the constitution. But it requires me to go into certain specifics as well of what doctrine of basic structure of the constitution is. And this is what the difference between polity and PSIR is. Now, why am I telling you all of this? I'll come to that, and I'll come back to this particular case, and we'll discuss a bit more about this case in order to tell you how we exactly need to approach polity with the lens of one particular topic. Firstly, let's look at what the syllabus of the PSIR in paper 1 is. As you people would know, there are 2 papers in any optional. PSIR also has 2 papers. Paper 1 has 2 sections. Section A is related to theory and thinkers. This is where you will be covering a large number of thinkers of political science and understanding what they say about the subject of political science and political theory. Paper 1 section B is what is that I will be covering as a part of the PSI optional classes. Okay, so the Indian government and politics portion, which would include principles like, or topics like constitution, topics like federalism, what are some of the institutions that exist in India, whether they are statutory or regulatory institutions, and some aspects related to the movements that have taken place in India post-independence, as well as the party system and its relationship to the same. 250 marks for this particular paper. What are some of the specific topics which are there as a part of section B of paper 1? We have Indian nationalism, things about Indian national movement, making of India as a nation, the process of drafting of the Indian constitution, what were the inputs that went into the drafting of the Constitution of India, starting from the objectives resolution, what was the role that was played by the various committees of the Constituent Assembly of India, what was the role that was played by the constitutional advisor B.N. Rao, what was the role that was played by B.R. Ambedkar, what were the different views that existed in the Constituent Assembly of India, whether it is from K.M. Panikkar or whether it is K.M. Munshi or whether it is Kalladi Krishna Swami Iyer or whether it is someone like Amrita Kaur, what were the issues that, or what were the ideas that existed, what were the various thoughts that were espoused in the Constituent Assembly of India is something that we will be reflecting upon in this. Then salient features of Constitution of India. When we always talk about that Indian Constitution is a borrowed constitution. In polity, we study that what are the principles in the Indian Constitution that were borrowed from the other parts of the world. In PSIR, we are not only going to be studying that, because that's the basis, but we will understand that why is it that we went for the idea of procedure established by law and not due process of law in our constitution. Why is it that we went for a written constitution and not an unwritten constitution? And all of this we will not be just studying it generally, but from the perspective of various scholars of political science, some of the most prominent thinkers of political science. Not only that, but another example would be that in our constitution, we have included right to freedom of speech and expression, just like the way the Americans have included into their constitution. But what is the difference? How is right to freedom of speech and expression in India very different from the right to freedom of speech and expression that exists in the United States of America, and how does it actually work out in practice? In real, what is the difference between the two? That's what we are going to be studying. And why is it that we did include specifically some of the grounds for restricting freedom of speech and expression in our constitution, not something that you would find in the American constitution? Why is it that the Americans had to go through the process of amending their constitution multiple times in order to include the fundamental rights in their constitution, and we went ahead with fundamental rights from day one? Why is it that in our constitution we went for the idea of universal adult franchise, providing voting rights to each and everyone in this country irrespective of their educational status, social status, economic status from day one? And why is it that in some of the countries like Britain or United States of America, this process of granting voting rights to the citizens was done in a phase-wise manner? Okay. So we will be going into the why, and we will try to understand it from the lens of various political thinkers and scholars. Has this really worked? Has it not worked? And things like that. Similarly, another topic is principal organs of the union and the state governments, and we'll be trying to understand the interaction between these various organs of the union and the state, whether it includes the judiciary, whether it includes the legislature, the executive, what is the role that is supposed to be played by them, what is the critique of the functioning of these institutions as we see at present. Certain aspects related to grassroots democracy, Panchayati Raj institution, urban local bodies. What was the reason for us to not go ahead with grassroots level democracy or Panchayati Raj institutions at the time of framing our constitution originally? What really changed in between that we actually had to go to that idea again, even though it was mentioned in DPSPs under Article 40? And someone like Gandhi was hell-bent on the idea of decentralized governance and decentralized democracy, but we still did not go ahead with that. But then, possibly 40 years later, we adopt that particular idea. What were the circumstances that led to the adoption of such an idea? Has it really worked in India? What are some of the roadblocks that we are witnessing as far as ensuring grassroots democracy in the country is concerned? We often hear about the idea or the problem of Sarpanchpati. Right? So, is that problem still there? What are the reasons, societal reasons? What are the economic reasons? What are the political reasons because of this idea existing in Indian democracy? What are the ways in which we can overcome it? So we will be going into the depth of the topics that we would be just touching upon when we are dealing with polity in general studies too. And then we have topics like statutory institutions and commissions, federalism. Today, Indian federalism is at crossroads again. We have seen the showdown that happened in the parliament just a couple of days back. And that is a classic example of how the states can also show their power to the center despite the centralizing tendencies of the constitution. Does Indian federalism require any kind of tweak or change? The existing arrangement that we have in India, do we need to bring about any changes in the way it functions? Has it worked well? If it has not worked well, what are the problems with the functioning of the Indian federalism? Again, these are certain things that we do touch upon when we take up polity as a subject in general studies paper 2, but again very superficially, on the surface of it. In PSIR, we will be going into the depths of these particular topics. So out of these 11 topics that you see in section B of paper 1, I specifically would be taking topics from number 2 to number 8. Okay? So those are the topics that I will be taking as a part of the PSIR optional classes. We'll be having round about 22 to 24 classes for these particular topics. Of course, it would be expected that you people know certain basics about the constitution and its working before you enter into the class, because we will be going into detailed analysis. We need to build a perspective which will help us score and fetch high marks in PSIR. So basics you will have to do to a certain extent on your own, but for those of you who have been studying from us, those who are students here at Vision IAS, those who are my students here at Polity, I can assure you that you will find the entire movement from Polity to PSIR very seamless in nature. Because once you have studied polity from me, you already know half of the subject already. Now the only thing that we have to do is that we have to deep dive into the subject in certain specific topics of the subjects, and we have to analyze from the lens of certain political science thinkers. So that's what we will be essentially doing as a part of these classes. Okay, so the point that I'm basically trying to make here is that most of you would anyway end up covering something like M. Lakshmikant or D.D. Basu or Subhash Kashyap as a part of your preparation for General Studies paper 2. And of course for the prelims examination as well, you would be preparing polity. The good part about PSIR as an optional is that this is not something which is new to you. It's not that you don't know what is doctrine, the basic structure of the constitution. It's not that you do not understand what is the kind of federal arrangement that has been made in India, which is centralized in its tendencies and which has a lot of powers given to the union as compared to the states. But here we will understand the why. Why is it that the center has been made more powerful than the states? What are the views that have been expressed by various scholars on constitutional law and of political science on this particular matter? What are the kind of similar arrangements that exist in other countries of the world? Has our system worked well? Do we need to learn from other countries of the world? These are some of the things that we will be exploring in the PSIR classes, something which we barely touch upon when it comes to polity as a subject. Right? So now, a few things before I get into the specifics of what these topics essentially are going to cover, and एक बार ये discuss कर लेते हैं, and then I will get into clearing some of the myths that exist as far as PSIR as an optional is concerned. First and foremost, if you look at the weightage of these particular topics which I said that I will be taking up as far as PSIR optional is concerned, there will be other faculties as well, but the topics that I'll be taking up, if you look at the weightage which is associated with these particular topics, you can see that they account for almost 130 to 170 of the printed marks of section B questions. So if the entire paper is 250, and if the printed paper, as you people would know, in optional papers you have a choice. You don't need to attempt all the questions, right? So you have to choose specific number of questions from section 1 and from section A and from section B of each of the papers. The total weightage of the printed paper is somewhere around 400 marks. Out of that 400 marks paper, it would be almost 150 marks would be coming from these particular topics alone. I have categorized these particular topics in order of their importance in tier 1, tier 2 and tier 3. Salient features of constitution, principal organs, federalism, planning, and these are some of the topics, the 4 topics out of the 7 that I'm going to be primarily covering. You will find that these 4 topics itself account for, as you can see, round about 100 marks out of the printed paper of paper 1. तो 400 में से 25% मार्क्स जो हैं वो इसी टॉपिक से कवर हो रहे हैं. Then after that, statutory institutions, grassroots democracy, making of constitution, they also add up to almost around 40 to 50 marks. So out of 250 marks and out of 500 marks which would be assigned to the optional, you could say that that portion that I would be taking would be somewhere roughly around 100 to 120 marks. Okay, so round about 25 to 30% of your marks in the exam in PSIR optional can be secured only through these topics alone. And why am I the person who will be teaching these particular topics? Because one, I have a substantial experience of teaching polity as a subject for the students, those who are studying general studies for a long period of time here at Vision IAS. Second, constitutional law, origin of constitution, perspectives related to constitution is something that I deeply study as a part of my job while I am practicing at the court. So if I have to argue in the court, I have to make certain solid substantial arguments. They cannot just be rooted in what the law says per se. They have to be rooted in the thinking, the views, the opinions of various political thinkers and the Constituent Assembly debates as well. And then also, given my substantial amount of experience of working with the government as a consultant, I also understand how constitution and law actually works in administration. So I have a unique position of having studied these particular topics, these subjects as a student who prepared for the exam, as someone who has been a practicing lawyer at the court and understands the nitty-gritties of these particular articles, and third, from the perspective of a practitioner as well who's been working with the government from the administrative point of view. And those are the three things that I will be bringing as an experience into my classes as far as PSIR as an optional is concerned. Now, before I get into further details of how exactly a class of PSIR would look, what are some of the things that what are some of the tools that we will be deploying in our classes as far as this optional is concerned, let me quickly dispel some of the doubts or the myths that usually exist as far as PSIR as an optional is concerned. A huge myth that exists among the students is this, which I can, let me call this as myth 1, which is that PSIR is a current affairs optional. Okay, that PSIR is a current affairs optional. That if you read current affairs, then you should be able to do well in PSIR as a subject. Let me clarify to you that if you have to do well in any optional, be it PSIR, be it geography, be it sociology, be it anthropology, any particular optional, first your basics have to be in the right place. You have to understand, you have to assimilate the subject like a way a student of any subject of humanities would do, which is to go back to the basics, to understand the subject from the perspective of the people, those who have laid down the foundations of that particular subject. Current affairs is something which will be an important part of your preparation for PSIR and for general studies as well. You can use the knowledge that you gain, you can use the perspectives that you get while reading newspaper editorials related to certain topics which are part of your syllabus. But that cannot be the basis of your preparation for PSIR. A very simple example will be, if there is an article that is written by Pratap Bhanu Mehta on how Indian federalism today is undergoing a huge, or is at the crossroads in many ways, or it's a very important juncture for Indian federalism, you can use the arguments that the author makes in his editorial in the Indian Express in your answers and quote him in your answers to drive home the point that you want to explain to the examiner. But that cannot be the sole thing which you can be writing in your answers. The point that I'm basically trying to make is that your answer would need to include historical perspective of what happened in the Constituent Assembly. Your answer would need to include perspective of what happened in the court related to various issues or conflicts that may have happened related to federalism in various court cases over the last 70 years or so, your answer would also need to include, in order to substantiate the view that you are expressing to the examiner with the help of the views of a particular scholar or a thinker of political science. So current affairs can help you in embellishing your answer. Current affairs can help you in adding more perspective and depth to your answers. But that cannot be the sole basis of writing the answers in PSIR. That is one thing that you need to understand. Second, PSIR as an optional awards political science graduates, which essentially means that only political science graduates are the ones, those who end up doing well in PSIR as a subject. That is not true. You look at the kind of performance that some of the students in the past from here as well as from elsewhere have shown in PSIR, you will find that many of them were having no background in political science at all. Of course, you have a certain edge that if you have studied a particular subject for years while you were graduating in that subject or while you were pursuing masters in that subject, you would know that subject, there would be a great amount of familiarity with that subject, but that does not necessarily guarantee you marks in the exam. If you look at the 2022 topper, Ishita Kishore, she ended up getting 318 out of 500 marks in PSIR. Even this year, when PSIR has not produced the best of the results according to its historic performance, you'd find that there are several toppers from PSIR in the final merit list. In fact, it is one optional which has a significant amount of overlap with your other subjects. Polity, of course, there is a huge overlap. There is a huge amount of overlap with governance topics in paper 2 of general studies in mains. International relations will be like at the back of your hand if you are a PSIR optional student. If I talk about paper 4, which is ethics, there as well you will find that your understanding of PSIR as a subject will help you in writing better answers to the questions that you encounter in case studies and theory portion of paper 4. A very simple example will be, you could always be using the views and the ideas of what you get from reading Aristotle or a Plato or a Jeremy Bentham or a John Stuart Mill in your answers without naming those particular scholars in your answers in paper 4. And we've seen many students do that year after year, and they tend to do better than other students. You don't need to necessarily quote Aristotle in your answer. If you want to, that's your choice. But in paper 4 on general studies, even if you don't quote Aristotle, but you just write the idea of Aristotle, the virtue-based ethics of Aristotle is an idea that is given by you without naming the scholar, without writing virtue-based ethics. But where you say that this is the right thing to do because it will uphold certain ideas and values that a civil servant must uphold, you are simply stating what virtue-based approach of Aristotle is in your answer and nothing else. And that in itself gives you a slight edge over other candidates. Then if I come to even essay, every year out of 8 topics, you will find that at least a couple of topics there will be either direct or indirect linkage to political science, to what is happening around us, international relations. You can use examples that you read as a part of a preparation for PSIR, international relations, politics, constituent assembly debates, issues related to various political movements. All of those things can also be brought into your essay as examples. You need not specifically write jargon. You need not specifically write scholar name. You need not quote Pratap Bhanu Mehta. You need not quote Madhav Khosla. But even if you can write that idea in your essay, you will have a slight edge over your competitors. Even for paper 3 of general studies, topics such as internal security require some understanding of what happened in India post-independence. If you have to understand Naxalism, then it's very important to understand what exactly happened in India after independence. that led to the rise of Naxalism. Ultimately, in many ways, even though Naxalism is a law and order problem, it was a political problem as well. Insurgency in Northeast, as much as it is a security problem, it is a political problem over assertion of identity also. So when you understand these issues better in PSIR, you can use that perspective in a general sense to write better answers in general studies as well. Same goes for topics like disaster management, environment. Today, environment as a problem, climate change as a problem cannot be solved by the union or by one state alone. It requires cooperative federalism. So in PSIR, you would understand what the concept of cooperative federalism is. Why do states need to come together along with the union to solve some of the problems of the country? And that's where you can use that particular angle in your answers when you're writing the answers related to environment or when you're writing answers related to disaster management. In paper 1 as well, society as a topic, you need to know various social phenomena, various changes that are taking place in the society. A large number of social changes that take place in the society are a result or a product of political movements and vice versa. What I mean to say is that often political movements lead to changes in the society. A very simple example will be how the tribals have been guaranteed their rights in the constitution now because of the political movements that took place in India under leadership of individuals like Phule or Ambedkar. Not only that, but the society also shapes political movements. It was the requirement of the society where there was a lot of frustration against corruption within the government that led to a movement like India Against Corruption. So you can explain political movements with the help of social changes and vice versa, and that's also something where PSIR as an optional will help you. It may not help you in directly answering all the questions, but it will help you in building a better understanding of those topics. In case you do not have exact content to write in a question related to society in paper 1, you may still be able to write something which is going to fetch you some marks from the examiner because you understand that topic in its entirety. Broad level perspective is there. So you can use that broad level knowledge and perspective to write something which is legible. You may not get 6 out of 10, you may not get 5 out of 10, but you may probably get 3 or 4 out of 10. This is also another advantage which PSIR gives to you. And last and most importantly, even in the interview, irrespective of whether you are a student of PSIR or not, do expect questions related to constitution in the interview. Do expect questions related to law. Do expect questions related to politics. Do expect questions related to political movements. All of these things also you will be able to answer better if you are a PSIR student. This is not to say that this is the only optional that should be taken by the students who are appearing for the exam. But if these issues, political movements, ideas of various scholars related to how power should be distributed in the society, ideas around how constitution was framed, what are the issues associated with the working of Indian constitution, whatever that is happening internationally today, what are the reasons for those conflicts, what we can expect in future, is there going to be a change in world order? If these are the questions that interest you, is China going to be now the #1 country in the world in the future and is going to trump over United States of America? If that is a question that excites you, if it excites you that what will be future of India in this new global world order, will India be a part of UN Security Council or will UN be dismantled completely, because you see that UN has been most ineffective in controlling any of these conflicts. So why don't we dismantle that organization? And if we are going to dismantle that, are we going to come up with an alternate? What are the characteristics of that alternate organization going to be? What all will be its representation? What will be its powers? What will be the role that it will play? If these are some of the ideas and questions that excite you, then I would say that PSIR is an optional that will interest you a lot. Also, another myth that is associated with PSIR is, so myth number 3. which is that you need to read 100 books or possibly even more to ace PSIR as an optional. For the topics that I discussed just now, I would tell you that there are 4 primary sources that you need to refer. 4 मेन किताबें पढ़ने की ज़रूरत है, और उसमें भी बहुत सारी किताबें कवर टू कवर पढ़ने की ज़रूरत नहीं है. उसमें केवल 1-2 किताबें होंगी जो कि बहुत पतली हैं, which you will have to read cover to cover. Except that what we cover here in the classes, what readings I tell you, that these are the things that you need to refer from these specific books. You can find those books either in the market, you can buy them, you can get photocopy of them, or you can even find PDFs online. Only those specific chapters, along with what you read in the newspapers and what we cover here in the class, should be more than enough for you to do well in this particular optional. At least for the topics that I am going to be covering, that will be more than sufficient. In fact, in PSIR, what is required is the same thing that we recommend in GS again and again, which is एक ही चीज को बार बार मल्टीपल बार पढ़ना. To be able to understand Granville Austin's views on the Keshwananda Bharati case, to understand H.M. Shirvai's views on the Keshwananda Bharati case, उसको बार बार पढ़ना और उसी को रिवाइज करना और उसी के ऊपर अपना खुद का एक ओपिनियन बिल्ड करना is what is required in PSIR. There is another interesting thing. If you are someone who struggles with building an opinion on an issue, then I would say that PSIR is a perfect optional for you. A few days back, just 3-4 days back, I got mail from one of the students and he said that, sir, this entire delimitation exercise and 131st constitutional amendment bill, I am very confused because there are number of articles which are criticizing it, and then there are number of articles that are supporting it, and I don't really know that what should be my view on this particular topic. I am confused. What do I do in such a matter? This kind of confusion is legitimate because unfortunately or fortunately, whatever we are reading in the newspapers today is largely an opinion of individuals. Earlier, the opinions were restricted to editorials. But when you read the newspapers today, I was reading the newspapers the next day after this particular amendment bill failed in the parliament, everyone has tried to write the headings in the newspapers according to the side on which they stand. If you are someone who supports the government, then you would say that opposition was responsible for the failure of this bill, as if opposition consists of some devils and villains, those who have made it a point to destroy India. On the other hand, in some of the newspaper articles, you would find that this particular bill was only supposed to destroy India's federalism and to completely do away with the powers of the southern states, as if that's the only thing that is on the agenda or the minds of those who are sitting in the government. The truth lies somewhere in between. And an intelligent person should be able to distinguish between what is an opinion, what is a view, and what is a fact, and what is the opinion that I need to have on that particular issue. If you are a student of PSIR, you would not only have strong opinions, which you should have, but they should always be open to change as well. But you would also have informed opinion on these particular topics and issues, much better than any other candidate who would be preparing for the exam. I'll give a simple example that if you are a mathematics optional student, how much can you understand about the delimitation and federalism exercise while you are preparing for general studies as a topic? कितना ही पढ़ सकते हैं आप. पर जब आप इंटरव्यू के अंदर बैठेंगे तो एग्जामिनर आपका व्यू जानना चाहता है, वो ये उसको मेंस का आंसर नहीं चाहिए. दिस इज समथिंग दैट वी टिपिकली सी in the answers that are provided by the candidates in the interview. Those who end up doing poorly, they try to sit on the fence. Neither do they answer this or nor do they answer that. They try to give answers like mains कि ये भी है वो भी है और दोनों चीजें होनी चाहिए. एग्जामिनर के लिए तो ये काम करता है एग्जाम में, रिटन एग्जाम में, बट इंटरव्यू के अंदर वो आपका ओपिनियन सामने से देखना चाहते. दे वांट टू नो हाउ यू थिंक, and they do not want any of these diplomatic talks to be made in front of them. I can guarantee you that if you are a PSIR student, you would have a much clear view on these particular issues as compared to the students, those who are not having this as an optional. Again, this is not to say that if you have this as an optional, then you are going to be at a significant advantage as compared to the others. But yes, there is a slight advantage that you have over the other candidates for the exam. Okay. So these are some of the things that we need to keep in mind as far as myths associated with this exam is concerned, that you do not need to read a lot of books. PSIR in fact has been one of the best performing optionals in the last few years, if you would have gone through the results. The other interesting thing which you need to keep in mind is that, see, PSIR is not about becoming a scholar, but PSIR is about having clarity on issues and topics that come in front of you while you're preparing these particular topics. Okay. So now, without much ado, let me just go into discussing one of the topics to give you an idea of how we are essentially going to be covering topics when we take up these topics in our classes in PSIR as an optional. First and foremost, before I move into that particular segment, so the topics that I'll be covering would be almost 85% of section B of the printed paper, but overall, if you look at it, 43% of the entire paper 1 will be covered via the topics that I'll be covering in the classes, and the returns on investment in PSIR are significantly more than some of the other optionals that are available for one to choose. Okay. Of course, there is another myth which is associated with PSIR, that this is an optional that takes a long time. Our commitment here is that we will try to cover the entire PSIR optional syllabus within a period of 6 to 7 months. That's the commitment that we are making to our students, so that, let's say, if the course starts somewhere in June, then we will be trying to cover the entire syllabus and the last class to be conducted by December end, so that you have ample amount of time, if you're preparing for the exam next year, to focus into move on to the prelims mode as well, possibly after February, and then you would still have 2 months period in between to go and revise certain things related to the optional, to go and revise whatever you have studied related to general studies mains as well. And of course, in our classes, we will be strictly emphasizing on answer writing practice and telling you what your approach to answer writing of PSIR has to be. How is it different from writing answers as far as general studies is compared, and we will try to bring in experiences from some of our past students as well, those who have written answers from the topper answer copies, to show you what exactly is required in order to secure high marks in PSIR as an optional. Anyway, so now let's start with this is something which is very unusual. I mean, when we have these open sessions, we usually don't tend to teach topics per se. Okay, but in today's session, I thought that it would be a good thing that if you can get an idea of how we will be approaching any of the topics in PSIR classes, so that you can make up your mind that this is something which I want, or this is something that I like, or this is something that resonates with my style of learning. Okay, so now, starting with the basic structure doctrine and the Keshwananda Bharti case. Now see, all of us know that the Keshwananda Bharti case was pronounced on 24th of April, this judgment was pronounced on 24th of April 1973. I often jokingly tell my students that this date is significant for 2 reasons. One, because this is the date when Keshwananda Bharti judgment was pronounced by the court, but also because the legendary Sachin Tendulkar, perhaps the greatest Indian cricketer or Indian batsman to have played the sport of cricket, was born on the same day. Right? So for 2 significant reasons, this is a very important date as far as India is concerned. But let's talk about Keshwananda Bharti case now. The Keshwananda Bharti case, 24th of April 1973, was essentially a judgment that was pronounced by the Supreme Court of India in response to some of the changes that were made in the Indian Constitution by the Parliament of India. So the Parliament of India had made significant changes to the Constitution, 24th, 25th, 26th and 29th Constitutional Amendment Act. 24th Constitutional Amendment Act had made certain changes to the text of Article 368 and Article 13 of the Constitution. Article 368 and Article 13 were amended, and the change that was made in principle, and I'm not going to do the exact specific provisions of the article, was that no constitutional amendment under Article 368 can be challenged in the court on the grounds of violating fundamental rights, which is, if there is any constitutional amendment act that is made under Article 368 of the Constitution, the courts in India cannot invoke Article 13, which allows the courts to declare a law as null and void on the grounds of violating the fundamental rights, which means that a constitutional amendment act can go and make such a change that even violates or completely removes the fundamental rights, and the court will not be able to look into such matter at all. So for example, if the parliament tomorrow goes ahead and removes Article 25 from the Constitution and says that no, people in India should not have right to freedom of religion or to choose or practice or to profess or to propagate their own religion, there can be no challenge that can be made in the court on the grounds that it is violating the fundamental right to religion in our Constitution. The second was 25th Constitutional Amendment Act, which had added an article into the Constitution, which was Article 31C. Right? So Article 31C of the Indian Constitution was made as an exception to fundamental rights. In polity, we always study that 31C basically says that if there is a law which has been made by the state that is to enforce what is mentioned in DPSPs under Article 39 Clause B and 39 Clause C, such a law cannot be declared to be void on the grounds of violating the fundamental rights under 14, 19 and 31. In simplest of the words, if there is a law which has been made to give effect to or to enforce DPSPs under Article 39B and C, even if such a law violates fundamental rights under Article 14, 19 and 31, courts cannot declare such a law as void. Normally, any law made by the parliament or by the state legislature that is violative of fundamental rights can be declared as unconstitutional by the courts under their powers of Article 13, but here that cannot be done. So now see, two things are happening. 24th Constitutional Amendment Act is one giving powers to a Constitutional Amendment Act over the powers of the courts under Article 13. Second, 25th Constitutional Amendment Act is giving powers to an ordinary law as well over the powers of these courts under Article 13 with respect to Article 14, 19 and 31. So in a way, you are weakening fundamental rights via both of these. Here you are saying that fundamental rights can be weakened by a Constitutional Amendment Act. Here you are saying that they can be weakened by a law. Then 26th Constitutional Amendment Act had abolished something which had been promised by the leaders of India at the time of independence, which is called as Privy Purse. So the government carried out what is called as the abolition of Privy Purse, which is basically a certain amount that was to be paid as a maintenance to the whom? A certain amount that was to be paid as a maintenance to the princes in India on the condition that they would join the Indian Union. This was a bait that was used by the leaders of India, especially Nehru, in order to win over the confidence of the princely states and to integrate them into India after independence, to prevent India's breakup into a number of smaller states. And then the 29th Constitutional Amendment Act, what it had done is that the Kerala Land Reforms Act, which I was mentioning, Kerala Land Reforms Act, a law which had been made by Kerala legislature that allowed them to take away the properties of individuals and of institutions, which had also taken away the property of this particular mutt in Kerala, was placed in Schedule 9 of the Indian Constitution as a result of the 29th Constitutional Amendment Act. All these Constitutional Amendment Acts were challenged in the Supreme Court of India in the Keshwananda Bharti case. But this is not where the story actually started. So when we are a PSIR student or whether we are a polity student, it's important for us to know what the background of the history was. So let's try to understand that how did we reach here? What exactly led to this 24th, 25th, 26th, 29th, etc. But before that, what did the court say in this particular case? The court upheld the validity of 24th. The court partially upheld the validity of 25th. The court upheld the validity of 26th and 29th Constitutional Amendment Act as well. So in a way, the people, those who were fighting this case, the petitioners, if you look at it, actually they lost the case. But the judgment that was given in this case had significant ramifications on India's constitution and its interpretation, because even though you can see that primarily judgment was given in favor of the government, because the court is saying yes, no Constitutional Amendment Act under Article 368 can be challenged in the court on the grounds of violating the fundamental rights, which means that in some ways I can say Article 368 is going to stand over Article 13 of the Constitution. This one is essentially saying that some DPSPs are important, have importance over some of the fundamental rights. This one is saying that whatever may have been the promises that were made at the time of independence, those promises are no longer valid. And this, of course, is legitimizing the power of the state to take away an individual's or an institution's property and still say that there has been no violation of fundamental right and it cannot be struck down by the court. So in a way, the winner in this particular case was the parliament or the government, but yet during the judgment, one of the defining moments was that one of the judges out of these 13 judges of the Supreme Court of India floated a note. And that note stated that the parliament should not have unlimited powers to amend the constitution. It can amend fundamental rights, no problem. It can amend preamble, it can amend any part of the constitution, but there are certain limitations that should be imposed on the powers of the parliament to amend the constitution. As a result of any amendment of the constitution, some of the basic principles and the values of the Indian constitution should not be affected in any way. Granville Austin, one of the foremost scholars of Indian constitution, someone who had studied Constitution of India extensively, had called Keshwananda Bharti case, and I will discuss that with you, why he said that. So this is an image of Granville Austin, and he says that the court in Keshwananda Bharti case did not save constitution from parliament, but it saved the parliament from parliament itself. In PSIR optional, we need to understand what exactly this statement means. There is a deep meaning behind this statement. यूजुअल अंडरस्टैंडिंग क्या है हमारी? केशवानंदा भारती केस में सुप्रीम कोर्ट ने इंडियन कॉन्स्टिट्यूशन को पार्लियामेंट से बचा लिया. दैट पार्लियामेंट does not use its amendment powers to completely change the constitution which has been written by our forefathers. But Granville Austin is saying that the parliament was saved from parliament via this particular case. What does this mean? That's what we need to understand. If I give you a hint of what this means, before I give you the hint, can anyone guess what this means? When he says that it saved parliament from itself and not the constitution from parliament, this case. What does this mean? क्या मतलब हो सकता है इसका? Any one of you who may want to take a guess? And there are no wrong answers, okay? So think and tell me what you think. What is your view on this? Why is he saying so? Court did not save constitution from parliament, but it saved the parliament from itself. बताइए. General understanding is that Constitution of India was saved from defacement by the parliament via this particular case. This was a case that was a conflict between the parliament and the judiciary. But अगर आप इसकी एक लेयर और डीपर जाएंगे तो आप ये सोच के देखिएगा, why save the parliament from itself? See, the parliament which had enacted these constitutional amendments, 24, 25, 26, 29th, was it democratically elected? Was it democratically elected? 1971 elections happened in India or not? Parliament was democratically elected with huge majority. They went ahead and made the changes to the constitution. So the problem was not that the parliament did not have legitimacy. क्योंकि अगर हम ये बोलते हैं कि कॉन्स्टिट्यूशन को पार्लियामेंट से बचा लिया, तो आप क्या कहना चाह रहे हैं? इन अ वे यू आर ट्राइंग टू से दैट कॉन्स्टिट्यूशन वाज सेव्ड फ्रॉम पीपल ऑफ द कंट्री, बिकॉज अल्टीमेटली पार्लियामेंट इज चोजन बाय द पीपल थ्रू an astounding majority, and you are saying that you saved the constitution from parliament, then you saved the constitution from people of India. The point is that parliament, by giving or bringing into effect 24th Constitutional Amendment Act, had given itself such extensive powers that it could do a lot of draconian things in future, including completely removing the basic principles of the constitution, which is the basis for the parliament's existence itself. That's why he's saying that in this case the parliament was saved from itself. जिस कॉन्स्टिट्यूशन से आप बने हैं, आपकी पार्लियामेंट तो लेजिटिमेटली इलेक्टेड है, आपकी पार्लियामेंट को हम ट्रस्ट करते हैं कि आपने ये चेंजेस राइट पर्सपेक्टिव से किए होंगे. बट can I say the same about future parliaments? Can I trust that in future also people, those who will be sitting in parliament, will be the correct people? If wrong people enter into the parliament tomorrow and they go about and make massive changes into the constitution, which itself is the very basis for the existence of the parliament, would the idea of parliament itself not get destroyed? तो अपने आप को पार्लियामेंट को अपने आप को भी बचा के रखना है, क्योंकि पार्लियामेंट भी अल्टीमेटली कॉन्स्टिट्यूशन से अपनी पावर्स डिराइव कर रही है. एंड दैट्स व्हाई ही इज सेइंग दैट दिस केस सेव्ड पार्लियामेंट फ्रॉम इटसेल्फ, फ्रॉम फ्यूचर पार्लियामेंट्स. दिस केस सेव्ड कॉन्स्टिट्यूशन फ्रॉम फ्यूचर पार्लियामेंट्स. दिस केस सेव्ड द फ्यूचर पार्लियामेंट्स फ्रॉम द draconian powers that would have been given by the present parliament to the future parliaments. And that is what this case did. तो उस level of understanding में हमें जाना है. ऐसा हो सकता है that UPSC may actually give exactly the statement in the exam, and they may ask you to analyze this. And that's what PSIR requires. So you would notice something. It's not that you require a lot of knowledge in order to transform from PSIR to a from polity to a PSIR student. All that you would require is some perspective of scholars, some perspective of thinkers on a particular issue. Once you have that understanding, then you will be able to deal with these topics in a much better manner. Anyway, now I'll come back to this topic again. So the Parliament of India enacts these constitutional amendment acts, and a lot of drama also unfolds in the Supreme Court of India when this particular judgment was given. The Chief Justice of India, Justice Sikri, he was due to retire in a few hours after this particular judgment was pronounced by the Supreme Court of India. Once Justice Sikri retired, the next thing to be decided was that who's going to be the next Chief Justice of India. And that's where again another political implication of the judgment was to be seen. Normally, till 1973, the principle that we had followed with respect to the appointment of the Chief Justice of India was following a principle called as the seniority principle, which is on the date of the retirement of the sitting Chief Justice of India, whoever would be the senior most judge of the Supreme Court of India in terms of years spent in the Supreme Court of India, number of years spent in Supreme Court, that person would be appointed as the CJI. But for the first time in India's history, after 1950s and after the constitution had come into force, we broke this convention. The government went ahead and appointed a relatively junior judge, superseding 3 senior most judges of the Supreme Court of India as the Chief Justice of India. This was in direct response to what had happened in the courtroom. This also tells us something very interesting, that not only was it a tussle between 2 provisions of the constitution, this case, but it was also a tussle between the parliament and the judiciary, or the executive and the judiciary, where each one of them is playing a tug of war. So that was the fallout of this particular judgment of the court, which we need to be aware of. Interestingly, these 3 judges, those who had superseded, were among the 7 who had given majority judgment on the issue that Constitution of India cannot be amended completely by the Parliament of India. So if you look at it, out of 13 judges, only 7 had given this verdict, that Constitution of India cannot be completely amended. Basic principles cannot be violated as a result of any amendment made to the Indian Constitution. Out of these 7 judges were the 3 judges, those who were superseded, those who would have gone on to become Chief Justice of India, but none of them were made. The 4th in number, a junior judge, was made Chief Justice of India for the first time. This is the first time that something like this happened in India's constitutional history, and that was a wider ramification that we need to be aware of as far as PSIR as an optional is concerned, because that also gives us a perspective on how institutions, executive and judiciary, or parliament and judiciary, also often get into a conflict with each other. Now, before I get into exactly what happened as a result of this, and we try to discuss one question related to this particular topic of doctrine of basic structure, of what was asked in UPSC in PSIR optional, and what is the kind of answer that we need to provide to it, let me just get quickly into the history of what exactly happened that led to this case. So the image that you actually see is that of Shankari Prasad Singh Deo. He was a rich zamindar from Bengal during the British rule. You can see one of the images of him with the hunted tiger, and then you can see this is the report that had come on 11th of January 1951, where a zamindari abolition bill had been passed in Uttar Pradesh. Okay, so in UP, zamindari abolition bill had been passed by the UP Legislative Assembly, and there was a lot of chaos that was going on in India at that point of time. So what exactly led to this Keshwananda Bharti case? The story begins several years earlier in 1950. 26th of January 1950, Constitution of India comes into force. One of the most important promises that was made by the Indian constitution makers, leaders of Indian freedom struggle, to the people of the country was that post independence we will implement a number of land reforms. So there was a promise for land reforms that was made to the citizens of India before independence. Especially because a large part of India's population was dependent on agriculture as a source of income, it made sense that these land reforms be implemented in order to do away with the wrong practices that had been introduced by British in colonial India, to ensure that the exploitation of the Indian farmers at the hands of the middlemen, the absentee landlords, can be removed. Now, so the Indian government therefore had made a promise for land reforms, and immediately after the constitution came into force, since land is a state subject, various state legislatures in India went ahead and started implementing land reforms via legislations. Among them, one of the states that went ahead and did so was Bihar. So Bihar became the first state in India to pass a Land Reforms Act. What are exactly land reforms? I'm not getting into that, but they passed what is called as the Bihar Land Reforms Act of 1950. So in a way, we are saying that promise of land reforms was translated into reality via laws of state legislatures. Bihar Land Reforms Act of 1950 is passed. But this particular Land Reforms Act was immediately challenged in the Bihar High Court. And that's where we can say the constitutional challenge to these land reform provisions or land reform laws came up in different high courts in India, starting from Bihar. The constitutional challenge that was made in the Bihar High Court was that these land reform laws go against the provisions of Article 14, 19 and 31. Article 14, that is right to equality, why only zamindars or big landowners have been chosen for these land reforms. Article 19(1)(f), which was right to property, that was guaranteed in our constitution originally, and Article 31 of the constitution, which was again right to property. And because Article 13 of the Constitution says that the state cannot enact a law that goes against the provisions of the fundamental rights, and to such an extent it shall be declared as null and void, challenge was made in the court. Interestingly, Bihar High Court agreed with some of the arguments that were made by petitioners in this case, and they struck down certain provisions of the Bihar Land Reforms Act. So the response of the court, or we can say that what happened in Bihar High Court was that they struck down several provisions of Bihar Land Reforms Act. Now this sent tremor waves amongst the government, because you must remember that India had still not undergone first elections. First election was supposed to happen in 1952. One of the major issues which the government was planning to use as an election manifesto or as an election pitch to the citizens of the country was that we are going to be implementing land reforms. But today, your promise of implementing land reforms that you had been making since decades has fallen flat on its face because of the very constitution that you have written yourself. So this was something which was very worrisome to the government. This is something which has been explained extremely well in a book which has been written by Triphudaban Singh, which is called as 16 Stormy Days, Story of India's First Constitutional Amendment. So a lot of things happened behind the scenes, and the government decided that we cannot let these things as it is. The reason being, today Bihar High Court has struck down these Land Reforms Act, tomorrow Madhya Pradesh will do so, then UP will do, and then everywhere else this will happen. One, this is going to be a political carnage for us. In elections, what is the face that we are going to show to the people of the country? Second is that we truly believed in land reforms. If we had to reform agriculture in India, we had to ensure equitable distribution of land in India to give rights to the farmers and not to absentee landlords. India's agricultural system would remain primitive in absence of these land reforms implemented in India. And you have to remember that almost 80% of India's economy at the time of independence was dependent on agriculture as a source of income, as an occupation. So you have to transform agriculture. For that you require land reforms. You have to win elections. For that you require land reforms. What do we do? So the Parliament of India goes ahead and makes the first Constitutional Amendment Act in response to this. So now the Parliament comes out with a response. Parliament's response therefore was to enact the first Constitutional Amendment Act barely 15 months into the writing of Constitution of India. 15 ही महीने हुए थे since the Constitution of India had come into force, but the Parliament goes ahead and changes the Constitution. And do remember that in the initial years, the Constituent Assembly of India played a dual role of not only writing down the Constitution, but also acting as the Parliament once its duty of writing the Constitution was done with. Because elections तो जो पहले हैं वो 1952 मिड में जाके खत्म हुए कहीं, तो सरकार बनने में अभी बहुत समय था. So Parliament in May of 1951 makes changes to the Indian Constitution via the first Constitutional Amendment Act. What were the changes that were made? One of the changes that was made was, and again I am not going to the specifics because then it will become too long a discussion, but some of the basic changes that were made was that we added one article into the Constitution called as 31A and 31B. Along with 31B, we also added Schedule 9 of the Constitution. Now what did 31A, 31B and Schedule 9 read together say? 31A of the Indian Constitution stated that if there is a law that has been made by the state for some of the objectives that are mentioned in this article, then such a law will not be declared as unconstitutional on the grounds of violating 14, 19 and 31. तो मतलब क्या किया गया, कुछ objectives mention किए गए 31A में. And if a law achieves those objectives under 31A, even if such a law violates fundamental rights under Article 14, 19 and 31, such a law cannot be declared as unconstitutional in the courts. 31B, so in a way 31A was exception to fundamental rights under 14, 19 and 31, which included objectives like acquiring estates, acquiring corporations, nationalization of industries. 31B on the other hand included that there is a new list which will be added to the Indian Constitution in form of Schedule 9. If there is any law that is passed either by the Parliament or the state legislature, and which via a constitutional amendment act is added to Schedule 9, such a law cannot be challenged in court on the grounds of violating any of the fundamental rights in the Constitution. Not only that, but if there was a law which had been declared to be unconstitutional by the court in the past on the grounds of violating the fundamental rights, and if later you amended Schedule 9 and put that law into Schedule 9 retrospectively, that law would become alive again, irrespective of whatever the judgment of the court was. Do you understand what I am trying to imply here? I can now, without going through the effort of passing Bihar Land Reforms Act again in the Legislative Assembly of Bihar, because passing a law is not an easy process. Bihar Land Reforms Act was debated in Bihar Legislative Assembly for over 2 months. Are you going to do that debate again for 2 months? No. So what is the solution? Amend Schedule 9, add Bihar Land Reforms Act into Schedule 9. Even though it was declared as unconstitutional by the court on the grounds of violating the fundamental rights, it will become active again simply because it has been placed in Schedule 9 of the Indian Constitution, irrespective of the judgment of the court. Understood? So 31A and 31B, essentially, I can say these two changes paved the way for land reforms in India. Now it seemed to the government that land reforms can be implemented effectively in the country. Okay? But the image of the person that we saw, Shankari Prasad Singh Deo, he went to the Supreme Court of India and he filed a petition in the Supreme Court stating that since a law cannot violate fundamental rights according to provisions of Article 13, how can a Constitutional Amendment Act, which is also a law technically, be violating the fundamental rights? Now understand this. What he's saying is, how have the land reforms laws been placed in Schedule 9?
via a constitutional amendment act, that is first constitutional amendment act of 1951. Now I am challenging the validity of not the Bihar Land Reforms Act which has been put in Schedule 9. I am challenging the Constitutional Amendment Act itself on the grounds of violating the fundamental rights. Why? Because Article 13 says no law can violate fundamental rights. Law, in opinion of the petitioner, that is Shankari Singh Deo, also includes a constitutional amendment act, which means that even a constitutional amendment act should not violate fundamental rights. Since first constitutional amendment act is violating fundamental rights, it needs to be struck down by the court. The government, on the other hand, is saying that law in Article 13, there is a definition provided given in Article 13 clause 3 sub clause A. लॉ का क्या मतलब होता है वो डेफिनेशन लिखी है, एंड इट डज नॉट इंक्लूड अ कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, एंड देयरफॉर a constitutional amendment act cannot be struck down by the court under the powers of Article 13 on the grounds of violating the fundamental rights. The court in what we know as Shankari Singh case, which is Shankari Prasad Singh Deo case, agreed with the government and stated that law is not equal to Constitutional Amendment Act. In other words, a Constitutional Amendment Act can violate fundamental rights. What were the reasons that were given by the court to come upon this particular judgment? We are not going to get into details of that right now, because then again we will exceed the limit of our session today. But we will just understand कि court broadly ये बोलती है. Several years later, in 1965, और ये देखिए बड़ा इंपॉर्टेंट है ये पूरी हिस्ट्री समझना, बिकॉज PSIR में यूपीएससी केवल ये नहीं पूछेगा केशवानंद भारती केस में क्या हुआ, यूपीएससी आपसे ये भी पूछेगा कि केशवानंद भारती केस तक पहुंचने का क्या प्रोसेस था, किस बेसिस पे ये डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर इवॉल्व हुई, क्या ऐसे पॉलिटिकल साइंटिस्ट के व्यूज हैं, Constituent Assembly के members के views हैं that led to the evolution of this particular doctrine. Anyway, so law is not equal to Constitutional Amendment Act. Several years later, another case came up in the court related to again property rights, etc., which was Sajjan Singh case. Sajjan Singh versus State of Rajasthan. In Sajjan Singh versus State of Rajasthan, a 5-judge bench of the Supreme Court of India said the same thing which it had said in Shankari Prasad case. So the 5-judge bench gave the same exact opinion which was given earlier in Shankari Prasad. But this time the judgment was 3:2. There were 2 dissenting opinions in the Supreme Court of India against the judgment that was given by the majority. Majority का view तो यही था, Constitutional Amendment Act does not include a law, which means that a Constitutional Amendment Act can violate fundamental rights. But 2 judges of the Supreme Court, Justice Mudholkar and Justice Hidayatullah, who later went on to become Chief Justice of India as well, both of them said that we do not agree with the judgment of the majority. Justice Hidayatullah said that fundamental rights are completely unamendable. If the fundamental rights in the Indian Constitution were written with the objective of being amended in future by the Parliament, then what is the purpose of writing the fundamental rights in the Constitution? Secondly, Justice Mudholkar goes on to say that Constitution of India can be amended, but there should be certain limitations on the powers of the Parliament to amend the Constitution. They cannot fully amend the Constitution. Fundamental rights may be amended, but in its effect, final effect, any amendment should not violate basic principles, basic values of Constitution of India. This is what Justice Mudholkar said. Justice Mudholkar's opinion itself was not something that was born out of thin air. Justice Mudholkar, in a way, if you know what is doctrine of basic structure, you would understand, was the one who brought the idea of doctrine of basic structure into the minds of the court, or the courtrooms in India. Doctrine of basic structure यही तो कहता है, कॉन्स्टिट्यूशन को अमेंड तो कर सकते हो, पर वो प्रोविजंस नहीं अमेंड कर सकते या वो अमेंडमेंट्स नहीं ला सकते जिससे कि बेसिक प्रिंसिपल्स अफेक्ट हो. Justice Mudholkar is also saying the same thing, that in its final effect, no amendment of the Constitution of India should end up affecting basic principles of the Constitution of India. Justice Mudholkar's opinion itself, now interestingly, see, this is what I want to show you, and this is how we need to prepare PSIR. हमें सिर्फ ये sequence of events नहीं जानना जरूरी है, but we also need to know something very important here. Wait one second. Sorry. Yes. The Supreme Court of Pakistan, in a case named as Fazlul Quadr Chaudhary and others versus Muhammad Abdul Haq, while considering a presidential order under Article 224 of Constitution dealing with elections, observed that the aspect of franchise and the form of government are fundamental features of Constitution, and to alter them in limine in order to placate or to secure the support of a few persons would appear to be equivalent not to bringing the given constitution into force, but to bringing into an effect an altered or a different constitution. The genesis actually of the doctrine of basic structure was coming from two sources. One was from this particular judgment of the Supreme Court of Pakistan, which had stated that you cannot alter certain basic values of the constitution, but because it would not amount to altering the constitution or making minor changes, but altering the constitution completely. Secondly, it also came from the provisions of German constitution as well. After whatever had happened in Germany when Hitler was at the helm of powers, Germans had made certain changes in their constitution, which including provisions stating that the parliament cannot change the constitution completely. There was a professor of constitutional law known as Professor Konrad in Germany, who had already talked about what is called as doctrine of implied limitations, which is, in every constitution there are certain implicit limitations on the powers of the parliament to amend the parent law, which is the constitution. These two were the basis for the writing of the judgment by Justice Mudholkar, and finally led to the idea of doctrine of basic structure in Keshwananda Bharati case. In PSIR, I need to know these things while I am writing my arguments to convince the examiner why doctrine of basic structure is important or where it came from. I cannot simply write it came from Keshwananda Bharati, because it's not possible, right? That suddenly one day judges of the Supreme Court of India would have woken up and they would have said that let's invent something like doctrine of basic structure. It was not invented. That's the point that I'm trying to make. Doctrine of basic structure was something that had been built upon existing ideas and had been built upon brick by the Supreme Court of India through its various judgments. And that's the question that we will be answering also in a bit, which was asked by UPSC a few years back in the mains examination. So I'll come back to this again now. 65, that judgment of the court comes. 67, another judgment of the court comes, which is Golaknath case. And this time, 11 judge bench of the Supreme Court of India contradicts the earlier judgments of the court, saying that fundamental rights in Indian Constitution are unamendable. In many ways, we can say that Supreme Court judgment in Golaknath was also based on an earlier judgment that was given by Justice Hidayatullah in Sajjan Singh case. So again, nothing has been built, no judgment has been given from scratch per se, is what I'm basically trying to say. So Sajjan Singh then leads to, or we have Golaknath judgment, Golaknath case of 1967, IC Golaknath versus State of Punjab, where the Supreme Court of India says that Constitutional Amendment Act is a law under Article 13, which means that a Constitutional Amendment Act cannot violate fundamental rights, which also means that fundamental rights, the court goes on to say, are unamendable. Now see, this judgment of the court is going on to other extreme. When you are saying that fundamental rights are unamendable, amendment is not always negative, it is also positive. I want to add new fundamental rights, I cannot do that as well because of this judgment that was given in the Golaknath case. And many of the critiques of this judgment believe that it has reduced the Indian constitution into an inorganic document. एक inorganic, एक dead document बन जाएगा इंडियन कॉन्स्टिट्यूशन. क्यों? क्योंकि अब कोई भी पार्लियामेंट आए, कितनी भी मेजॉरिटी में आए, इट कैन नॉट चेंज द कॉन्स्टिट्यूशन ऑफ इंडिया इवन इफ इट वांट्स टू. फंडामेंटल राइट्स के अंदर कुछ ऐड भी नहीं किया जा सकता है अकॉर्डिंग टू द रिक्वायरमेंट्स ऑफ द सोसाइटी. 1971, and see this judgment in many ways meant, अब इसको पॉलिटिकल साइंस के पर्सपेक्टिव से आपको ये भी समझना है कि उस समय पॉलिटिक्स में और सोसाइटी में क्या चल रहा था. दिस मेंट दैट it is going to be a big setback for various socialist measures that the government wanted to take up. The government wanted to bring about a number of socialist measures, including nationalization of industries, nationalization of banks, abolition of privy purse, land reforms across the country. Now that entire idea is going to go out of the window because you are saying fundamental rights are unamendable. No constitutional amendment act can be made which will weaken the fundamental rights. You cannot make any laws and introduce them into Schedule 9 of the Constitution and prevent them from the judicial scrutiny. So all these socialist measures are going to suffer. This was also a time when Indian politics was in a lot of turmoil. 1967 is when this judgment was given. The Congress party itself was undergoing split within itself. There was various factions within the Congress party. 1969, Indira Gandhi is expelled from Congress party. In fact, when the elections happened for the President of India's position, she does not support the candidate who was put up by Congress party, but rather an independent candidate. And that independent candidate ends up winning the election. She tells the members of the Congress party, those who were her loyalists, that you vote as per your conscience, not as per the direction or the whip given by the political party. So people do that. The independent candidate wins the election. Indira Gandhi is expelled from the Congress party because of anti-party activities. She goes on to form another political party which was called as Congress I. And now there is a direct confrontation between her and the other faction within the Congress party. And now in the elections, she needs an election pitch to go to the people and to get support for herself. And what is the election pitch that she uses? She goes to the people and says that I wanted to introduce a number of reforms for you people, for the masses of the country, including land reforms, including overtake of the industries by the government for the benefit of the common man. But there are forces within the society that are stopping me from doing so. So please vote in such large numbers for me in the next elections that I don't need the support of all of these people. I will bring about Constitutional Amendment Act to overturn the judgments of the court. And that's what exactly happens. 1971, she wins the election with astounding majority, comes back in power and enacts these 24th, 25th, 26th, 29th Constitutional Amendment Act as response to the Golaknath judgment of the court. So in a way, I can say that these setbacks and whatever happened in the elections paved the way for various constitutional amendment acts that we have discussed very briefly earlier as a response to what happened earlier, as a response to Golaknath and other judgments of the court and other things that were happening. And this is what was challenged in the Keshavananda Bharati case, and which the court upheld. But still, the court, instead of saying that no, fundamental rights are completely amendable or completely unamendable, it is taking a middle path where it is saying that fundamental rights can be amended, but not to such an extent that the basic values of the Indian Constitution are affected by any amendment made by the Parliament of India. The court, in a way, played a balancing act. It showed a very elegant way of not necessarily picking up a fight with the Parliament or the executive, but yet trying to find its way in between. Right? So that is what the judgment of the court in this particular case was. Now, look at what is the question that has been asked by UPSC, or what could be a possible question related to this topic in mains, and what could be asked in optional. तो GS में क्या क्वेश्चन हो सकता है और ऑप्शनल में क्या क्वेश्चन हो सकता है. उसके बाद देखिए, आफ्टर द केशवानंदा भारती केस देयर हैव बीन मल्टीपल जजमेंट्स ऑफ द कोर्ट in the Rajnarayan versus Indira Gandhi or Minerva Mills case, I.R. Coelho case, Kyoto Holohan case, S.R. Bommai case, through which the Supreme Court of India has expanded the meaning of what we know as doctrine of basic structure. Well, let's not get into details of that. अब देखिए, PSIR के अंदर आपको ना सिर्फ डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर को समझना है, बट आपको ये भी समझना है कि इस डॉक्ट्रिन के क्या क्रिटिसिजम्स हैं, और वो क्रिटिसिजम्स जेनेरिक क्रिटिसिजम्स नहीं हो सकते जो आप सोचते हैं, बट दे हैव टू बी बेस्ड ऑन द ओपिनियन ऑफ सर्टेन लीगल, सर्टेन thinkers, legal scholars, certain thinkers of political science. For example, Pratap Bhanu Mehta is giving a critique of doctrine of basic structure, where he's, and where will you find this? In the textbooks that we will be referring to, where he says that the doctrine risks judicial supremacy. It can lead to what we know as judicial supremacy, judiciary becoming the most powerful organ of the state, unelected judges blocking elected legislatures. There is no textual basis of this doctrine in Constitution of India. The court alone will decide what the basic structure of the Constitution is, and this is giving courts unlimited powers and paving the way for judicial dominance in a democratic setup. On the other hand, what are scholars like Granville Austin and Madhav Khosla saying? Granville Austin says that the doctrine prevented authoritarian capture during the emergency. So during emergency, there was an amendment that was made to the Constitution, 39th Constitutional Amendment Act, that added a provision to the Indian Constitution which put the elections of the President, the Vice President, the Speaker of the Lok Sabha and the Prime Minister of India beyond the purview of the courts, and put it in the purview of a tribunal which will be chosen by the government. तो अगर प्रेसिडेंट, वाइस प्रेसिडेंट, प्राइम मिनिस्टर, लोकसभा के इलेक्शन पे आपको कोई भी आपत्ति है, तो ये इशू जो है वो केवल और केवल आपके एक ट्रिब्यूनल के अंदर रेज कर सकते हैं, नॉट इन दी कोर्ट. सो यू आर टेकिंग अवे द पावर्स ऑफ द जुडिशियल रिव्यू, एंड दैट ट्रिब्यूनल कैन बी कंट्रोल्ड बाय द गवर्नमेंट. एंड व्हाई इज दिस इशू इंपॉर्टेंट? बिकॉज सी व्हाट एग्जैक्टली हैपेंड वाज दैट the 1971 elections of Indira Gandhi from Rai Bareli seat had been contested in the High Court of Allahabad by her opponent Rajnarayan, who had alleged that she had used, or she had rather misused, the government machinery for her electoral gains, which is a corrupt electoral practice under ROPA, and if you are found guilty of that, you can be disqualified from the parliament and from contesting the elections. Allahabad High Court, in its very important judgment on 12th of June 1975, had declared the elections of Indira Gandhi from Rai Bareli seat as illegal, as invalid, because she was indulging in corrupt electoral practice. And not only that, she was also disqualified from contesting the elections for a period of 6 years, which means that for 6 years her political career is going to go for a complete toss. Not only did Indira Gandhi obtain a stay on this particular judgment of the Allahabad High Court from the Supreme Court of India, but in order to prevent any such future challenges, she brought about this constitutional amendment. Now, this constitutional amendment, 39th, was struck down by the court during emergency on the grounds of the Keshavananda Bharati case, because what this Constitutional Amendment Act does is, it takes away powers of judicial review from the courts, which is a basic feature of the Indian Constitution as held by the court in Keshwananda Bharti. तो अगर केशवानंदा भारती नहीं होता तो 39th Constitutional Amendment Act would have been upheld as valid, and what would have happened? India could have gone into a dictatorship where once elected the Prime Minister, their election could not have been challenged in any court. It would have been challenged only in a tribunal, and that could have been controlled by the government. So Granville Austin actually said that it saved India's democracy. Several experts are going on to say that it saved India's democracy, right? Then Madhav Khosla, another prominent constitutional expert, another expert on political science and Indian constitution, says that it is an Indian innovation in comparative constitutional law, and other democracies have equivalent, Germany's eternity clause and US fundamental constitution principles. So when you are writing your answer in PSIR, if the examiner asks you, critically analyze doctrine of basic structure as laid down by the court in Keshwananda Bharti case, आप GS वाला आंसर नहीं लिखेंगे सिर्फ, that it gives too much powers to the judiciary, which is unelected, tyranny of the unelected, जो हम सब GS में लिखते हैं. हम GS में लिखते हैं that it helped in saving India's democracy. कैसे नहीं लिखने की जरूरत, हमें यहाँ पे वो लिखना पड़ेगा, and we will have to substantiate that view with the help of the views of certain scholars. That's the difference which you will find in writing answers in PSIR versus GS, and I will show you what the difference is in exactly as far as answer writing is concerned. अब देखिए PSIR में आपको contemporary development से भी relate करना है. 16th of October 2015 was another significant date. The image that you see is that of Justice Chelmeshwar. He was the only judge who had supported the NJAC Act. 99th Constitutional Amendment Act was brought in by the Parliament in order to establish an independent constitutional commission which would be responsible for recommending appointments to the President of India for higher judiciary. This NJAC was supposed to consist of 6 individuals: Chief Justice of India, 2 senior most judges of the Supreme Court of India, 2 eminent persons to be chosen by a separate committee that would consist of the Prime Minister, the CJI, and the leader of the opposition in the Lok Sabha, and it would also consist of the 6th member would be Law Minister, Union Law Minister. ये 6 लोग होंगे. The idea was that this collegium system has its own flaws of making appointments to the judiciary. We need to do away with this. This is very opaque, and we need to have a system where executive as well as judiciary both have a greater say in the appointment of the judges. This particular 99th Constitutional Amendment Act was struck down by the Supreme Court of India on the grounds of violating the basic structure. Why? Because the court stated that independence of judiciary is a part of basic structure, and independence of judiciary can only be ensured when there is primacy of judiciary in the committee that makes the appointment. 6 में से केवल 3 ही लोग judiciary के हैं, 3 नॉन जुडिशियल हैं, तो primacy नहीं है judiciary की. दूसरी बात, let us say that if CJI and the other 2 judges of the Supreme Court say that we want this particular person who is a judge of the High Court to be appointed as judge of Supreme Court, सरकार को वो आदमी पसंद नहीं है because उनको लगता है कि वो हमारे खिलाफ जजमेंट देगा, इसकी आइडियोलॉजी, ये बहुत ऑनेस्ट जज है, we cannot arm twist him, we cannot bribe him, we cannot force him, we cannot extort him, we cannot do things that will make him do things as we want him to do. We want to stop his appointment. What will I do? Out of 6 people, the provision was, even if 2 people disagree on a name, it will act as a veto. तो 6 में से 2 ने नाम के ऊपर अपना no लिख दिया, that's it, that's the end of the name, that's the end of it for that particular person to be appointed as judge of Supreme Court and High Court. This is where the court had problem, that 2 people can block the appointment of an individual as a judge of the Supreme Court or the High Court even if the judiciary is agreeing on that particular name. And that's why it compromises independence of the judiciary and it should be struck down. Why Justice Chelmeshwar? अब political science में हमें Justice Chelmeshwar को भी जानना जरूरी है, because NJAC में कोर्ट ने क्यों उसको स्ट्राइक डाउन किया ये तो पता होना चाहिए हमें GS के लिए भी. But in PSIR we also need to know why Justice Chelmeshwar gave the only dissenting judgment in this case. 5 judges की bench थी, in that only 1 judge gave dissenting opinion, and that was Justice Chelmeshwar. Justice Chelmeshwar said that, who says that independence of judiciary is dependent on primacy of judiciary in appointments. ये कहाँ लिखा है? I agree that independence of judiciary is a part of basic structure of the constitution, very important value to have, great. But who says that independence of judiciary is based on judicial primacy? Who says that judicial primacy or primacy of judiciary in appointments will lead to independence of judiciary? Where is it written? How does it make sense? And therefore, he disagrees with the judgment of the majority. The point is not that did that dissenting judgment have any great role to play? No, but it helps us in forming our arguments. If UPSC asks us to critically analyze the NJAC judgment of the court in PSIR optional, in that case we will have to bring Justice Chelmeshwar's point of view as well while we are writing the answer. Because हम कोई एक जो भी स्टैंड लें, हमें एग्जामिनर को ये बताना जरूरी है कि वो हमने सारे पर्सपेक्टिव, सारी चीजों को ध्यान में रखते हुए फिर हमने अपना फाइनल ओपिनियन दिया है. इट इज नॉट वन साइडेड ओपिनियन दैट आई हैव गिवन. इट इज नॉट बेस्ड ऑन वन साइडेड इंफॉर्मेशन एंड नॉलेज. वंस यू डू दैट, दैट इज व्हाट इज गोइंग टू सिक्योर योर मार्क्स इन PSIR एज कंपेयर टू GS, जहां पे आप ऊपर ऊपर से ये बहुत सारी चीजें लिखकर निकल सकते हैं और डेप्थ में जाने की जरूरत नहीं है. बट इन ऑप्शनल, optional, PSIR optional, you'll have to justify. In PSIR, more so with the help of the views of the scholars and the views of various thinkers of political science. Now anyway, so the doctrine, अब इसमें एक और चीज है, जब हम आंसर लिखेंगे तो हमें फिर कुछ कंटेम्प्रेरी और रेलेवेंस देनी है इसकी, that how the doctrine is operating today. Judgment given by the Supreme Court of India in electoral bonds case in 2024 was based on doctrine of basic structure only. The judgment that was given in the abrogation of Article 370 with respect to Kashmir was also based on this principle, where the court is saying that asymmetric federalism is not a part of the basic structure of the constitution. Just that because Kashmir has an asymmetric structure as compared to other states does not make it more important than the other states, and so on and so forth. And till now the court is still trying to find the right balance between doctrine of basic structure and the powers of the parliament to amend the Indian constitution. See, another interesting thing is that, I mean, you have to again think of other perspectives. Some of the views that have been expressed by some of the constitutional scholars is doctrine of basic structure need not be criticized because ultimately how many amendments of the constitution have been struck down by the Supreme Court of India utilizing doctrine of basic structure of the constitution? There have been a handful of them only. So it's not that the Supreme Court of India is invoking doctrine of basic structure every random day and is using them to strike down the laws made by the Parliament of India or constitutional amendments made by the Parliament of India. So to say that this has given draconian powers to the judiciary is going to an extreme. But again, you can have a different perspective as well on this particular matter. Now, the point that I'm basically trying to make is that this is what preparation of PSIR as an optional with the help of example of one topic requires. Again, of course, you must also understand that whatever we have discussed, this is not like the end of it. Okay, there are a lot of other things also that need to be brought into this. For example, I'll give you some of the arguments in favor of doctrine of basic structure of the constitution. Some people say that, अब जैसे हमने प्रताप भानु मेहता का व्यू देखा, where he says that it leads to judicial supremacy. Justice Chandrachud, not Justice D.Y. Chandrachud, his father, Y.V. Chandrachud. Justice Y.V. Chandrachud in Indira Gandhi versus Rajnarayan case had stated that this doctrine does not rest on judicial supremacy, but rather it rests on shared sovereignty. Judicial supremacy पे नहीं, on shared sovereignty. What that exactly means is, court's judgment on a particular constitutional amendment act to strike it down does not end the democratic dialogue. It rather is the start of it. कोर्ट ने 99th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट स्ट्राइक डाउन किया ये बोल के कि हमें एनजेएसी की कॉम्पोजिशन से प्रॉब्लम है. तो अब पार्लियामेंट और एग्जीक्यूटिव और वाइडर सर्कल्स में ये डिस्कशन हो रहा है कि ठीक है, ये तो ठीक नहीं है, ये तो कॉन्स्टिट्यूशन के अगेंस्ट है, पर ऐसा हम और क्या कर सकते हैं जो कि कॉन्स्टिट्यूशनली एक्सेप्टेबल हो. उसी के बाद executive and judiciary came together and they said that we will have what is called as memorandum of procedure, which will be certain defined guidelines and procedure which will be followed by both executive and judiciary to ensure efficient, effective, speedy, as well as an independent manner of appointment to the higher judiciary in India. So his point is valid. Now with the help of my knowledge of current affairs, that memorandum of procedure एक चीज होती है, with the help of my knowledge of what Justice Y.V. Chandrachud said, that it is not based on judicial supremacy but rather shared sovereignty, I can build an argument in my answer. PSIR में मैं केवल ये नहीं लिख सकता कि no, it does not lead to judicial supremacy. क्यों लिख के मेरे को क्यों बताइए, क्यों? Why are you saying so? और मैं तुम्हारी बात भी क्यों मान लूं? I need you to form your argument on the basis of the argument of some constitutional scholar, on the basis of judgment, on the basis of some particular view expressed by a judge or by a scholar or a thinker of political science. You do that, I will give you marks. That's what the examiner is expecting, right? Similarly, another expert on constitutional law and political science, Krishna Swami, he says that the doctrine has been invoked sparingly, जो मैंने अभी आपको argument दिया था, that the standards that we are trying to apply to the doctrine to declare it is undemocratic, it is too stringent. If the doctrine has been applied only in limited number of cases by the Supreme Court of India, to say that this leads to judicial supremacy and judicial tyranny is an over exaggeration. I write this with the help of the name of Krishna Swami as an opinion. That is when I am going to be getting the marks out of the examiner. That's the only difference. So बात मेरा कहने का मतलब ये है, polity is giving me almost 60% of knowledge of the subject. मुझे वो जो 30-40% फिल करना है, वो बस एक स्कॉलरली पर्सपेक्टिव, एक लीगल पर्सपेक्टिव, एक थिंकर का पर्सपेक्टिव उसमें और ऐड करना है और अपना ओपिनियन उसके बेसिस पे बनाना है. दैट्स ऑल. If I am able to do that, plus I am able to bring in some court judgments, if I am able to bring in my knowledge of current affairs, I am sorted for this particular portion of PSIR. And that requires very minimal amount of effort. As compared to, imagine if you were to pick up some completely different subject. Again, this is not to belittle that other subject. Let's say anthropology. I don't know anything about the evolution of the human beings. I don't know anything about the evolution of human society. अब मैं उसको बिल्कुल completely नए सिरे से जाके पढ़ूंगा, which may also be interesting to me. I'm not arguing that. But PSIR, it is easier if I have already a good base in a subject like polity. Okay. Anyway, so अभी होता क्या है कि लोग ना उल्टा देखते हैं हमेशा कि PSIR पढ़ लिया तो पॉलिटी अच्छा हो जाएगा. मैं इसको ऐसे देखता हूं कि आप पॉलिटी तो पढ़ेंगे ही पढ़ेंगे. अगर आपने पॉलिटी पढ़ा हुआ है तो PSIR करना आसान है, and then it will help you in polity as well, of course. Anyway, so now let me show you why and how this particularly matters. कि 3 लेयर्स के आंसर होते हैं. एक होता है GS स्टाइल आंसर, एक होता है GS स्टाइल आंसर में मैंने कुछ स्कॉलर्स टाइप कर दिए पर उसको प्रॉपरली एग्जैक्टली कहां पे लिखना है स्कॉलर को वो नहीं जानता हूं मैं, कैसे आर्ग्यूमेंट्स को सपोर्ट करना है. और तीसरा है जब मेरी एक thesis है, I have an idea, I use these scholars, I use the judgments of the court, and I also use my contemporary knowledge on the basis of certain evidence to write an answer. So let me show you the example of the same. This is the question that will be asked in GS. ये है GS का question. Discuss the role of Supreme Court in interpreting the Constitution of India. How has the basic structure constitutional doctrine evolved over years? तो इसमें आपको cases के बारे में बात करनी पड़ेगी. In this you would have to talk about what is the role that is played by the Supreme Court of India in interpretation of the Constitution, how through its various judgments it has helped in interpretation of, let's say, Article 21, or it has helped in extensive interpretation of Article 142, or it has helped in extensive interpretation of the conflicts that emerge between the Union and the states, etc. and so on and so forth. तो बहुत सिंपल एग्जाम्पल देके मेरे को GS के अंदर इसका एवोल्यूशन बताना पड़ेगा. So let's say for example in GS my answer will begin with that the Supreme Court plays an important role in interpretation of the Constitution. It has done the same in order to resolve various constitutional conflicts, for example so and so, and then specifically I will get into the doctrine of basic structure of the Constitution and its interpretation by the Supreme Court. Now in PSIR the question Now notice the difference in the language. PSIR, this is the question that UPSC asked in PSIR 2020 का question है. Basic structure doctrine is implicit in Indian constitution. The Supreme Court has only given it an explicit form. Comment. Write down this question. Take 2 minutes to think. I am not asking you to write down the answers, but think what all broadly this question is asking me to do, and then I'll tell you what ideally a good answer to this kind of a question would look like. Now, see, how will I write the answer to this question in PSIR? I am just giving as an example. This is not the exact answer. Of course, there can be a lot of variation in the way you write the answer. So the question is that doctrine of basic structure of the constitution is implicit in Constitution of India and the Supreme Court has only given it an explicit form. Comment. मतलब ये तो कॉन्स्टिट्यूशन में हमेशा से प्रेजेंट थी, सुप्रीम कोर्ट ने बस इसको डिस्कवर किया और इसको एक्सप्लिसिट बना दिया बोल के कि ये कॉन्स्टिट्यूशन में ऐसे लिखा है. कमेंट. दो पर्सपेक्टिव हो सकते हैं कि हाँ ये इम्प्लिसिट है. इम्प्लिसिट है तो कैसे प्रूव होगा इम्प्लिसिट है? इफ इट इज इम्प्लिसिट, हाउ विल आई प्रूव दैट इट इज इम्प्लिसिट? Either on the basis of Constituent Assembly debates or on the basis of the views that have been expressed by some scholars in the past who say that कि भाई ये था ही हमेशा से, or on the basis of the provisions of the Constitution itself that this is why it was always implicit in the Constitution. But then I have to also think that comment करना है. Supreme Court of India has only given it an explicit form. So I will tell yes that in a way this was implicit in the Constitution and Supreme Court has made it explicit, but to simplify it to such a level, to trivialize it to such a level will not be the correct assessment. Supreme Court of India has not only made it explicit but has actually made the doctrine of basic structure brick by brick through its various judgments. सेक्युलरिज्म इज अ पार्ट ऑफ बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन, तो कोर्ट ने एसआर बम्बई में बोला. और जुडिशियल इंडिपेंडेंस इज अ पार्ट ऑफ द बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन, तो सुप्रीम कोर्ट ने उसको एनजेएसी केस में बोला एंड देन दे अप्लाइड इट देयर. तो ये कहीं एक्सप्लिसिट तो नहीं था. दिस वॉज डन ब्रिक बाय ब्रिक. दिस इज ब्रॉडली वॉट माई आंसर शुड लुक लाइक. नाउ हाउ विल आई राइट द आंसर टू दिस क्वेश्चन? एंड अगेन all the embellishment etc can be done, but let's discuss what an ideal answer to that question of 2020 would have looked like. क्या क्या चीजें उसमें होती? My first argument would have been that this proposition, the proposition that doctrine of basic structure of Indian Constitution is implicit in the constitution is partly right. अब मैं इसको कैसे लिखूं वो कुछ भी हो सकता है, बट आइडिया ये आएगा एग्जामिनर को, इज पार्टली राइट बट इनकम्प्लीट. पार्शली तो ये ठीक है, बट दिस इन इटसेल्फ इज अ वेरी इनकम्प्लीट स्टेटमेंट टू मेक. I would say that the idea of doctrine may have been laid down by the framers. If I have to draw an analogy, I can say that the seeds of doctrine were sown by the framers of Constitution of India. Right? The seeds of the doctrine were sown, were planted by the framers of the constitution, but the tree itself has been grown, has been nurtured by the court over the years. So even though the basis was laid down by the constitution or by the constitution makers, but the branches of the tree have been grown by Supreme Court of India over decades. अब मेरे को इस बात, यहां से मेरा इंट्रोडक्शन स्टार्ट हुआ. अगेन आई एम नॉट गोइंग टू बी राइटिंग दिस इन पॉइंट्स पर से, बट दिस इज व्हाट माय इंट्रोडक्शन हैज टू हैव. अब मैं इसको सीड्स लिखूं, कुछ भी लिखूं, वट एवर आई राइट, बट ये आइडिया कन्वे होना चाहिए एग्जामिनर को. नाउ आई विल फर्स्ट टॉक अबाउट दिस, that yes, the seeds were indeed sown by the constituent assembly members. When, अब यहां पे मैं constituent assembly debates invoke करूंगा, I will invoke Dr. Ambedkar. When Dr. Ambedkar in the Constituent Assembly of India is defending Article 32 as the very heart and the soul of the Constitution of India, when he is essentially defending what we call as constitutional writs, he is saying that statutory rights, ones which have been given by a law of the legislature, remain at the mercy of the legislature, but constitutional entrenchment, which is inclusion of rights in constitution, is what is required to protect the rights of the citizens from the majority. He is essentially talking about nothing but doctrine of, वहीं पे तो एक seed implant हो रहा है doctrine of basic structure का, where he is saying that certain rights need constitutional protection, unlike statutory rights. Certain rights need constitutional protection unlike statutory rights. इसको बात समझने की कोशिश कीजिएगा, ये क्यों इंपॉर्टेंट है. ये डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर की तो एक तरीके से बात हो रही है, not in explicit form but as a seed. Statutory rights like MG Narega can be taken away by a law of the parliament. Constitutional rights he is putting in the constitution and saying that it has constitutional protection. What does that mean? That there are certain things that you cannot take away even by coming into majority. Parliament given rights can be taken away by a majority elected parliament, but constitutionally given rights cannot be taken away by a parliament that is elected by whatever its majority may be. I may also mention that, and there is a book which has been written by Madhav Khosla called as India's Founding Movement, where he talks about that how significant is the act of writing of the Indian Constitution and the bringing into action the Indian democracy, where he says basically that Indian democracy and coming of Indian Constitution into force is, in my opinion, an event as significant as the French or the American Revolution in the annals of world history. But उसकी बारे में इतनी शायद importance नहीं दी जाती है, बात नहीं की जाती है. So Madhav Khosla, अब now I will bring in Madhav Khosla then. Let's say I bring in Madhav Khosla and see again, ये ऐसा नहीं है कि ना ये कोई बहुत ज्यादा किताब है, आपको 50 स्कॉलर्स के व्यूज इकट्ठे करने हैं. आप 5-6 प्रोमिनेंट स्कॉलर्स के व्यूज इकट्ठे कीजिए, वो बहुत है. There is no need to run after hundreds. Just gather views of some prominent scholars, read those texts properly, utilize those particular ideas in your answers, and you will get the marks. So when I talk about Madhav Khosla's views, I will essentially be talking about that Madhav Khosla had said that the commitment that was shown by the Constituent Assembly members to insulate certain core ideas or principles from ordinary politics. So Madhav Khosla had said that core ideas were provided protection by the Constitution of India. From ordinary politics. Ordinary politics. Granville Austin, in his book Cornerstone of a Constitution, which again we will have to read as a part of our PSIR preparation, says that Indian Constitution is based on a seamless web of DPSPs, fundamental rights, preamble, which flow from one to the other. And this seamless web should not be disturbed. ये ग्रैनविल ऑस्टिन कॉन्स्टिट्यूशन की रीडिंग पे बोल रहा है, कोर्ट की जजमेंट पे नहीं बोल रहा है. Madhav Khosla is saying this on the basis of the reading of the politics of the day and the Constitution of India. So from this I can basically suggest that Constitution of India doctrine of basic structure was in many ways implicit within the constitution of the country itself. Right? Now, once I have done this, but then I will go to the other side. Someone like Krishna Swami, he mentions that the doctrine of basic structure was built by the court. The court has done way more than is recognized in terms of building this particular doctrine and its various principles. He goes on to say that doctrine of basic structure does not rest on any one single article of the Indian Constitution, but is a multi-provisional structural interpretation of the Constitution that has been made by the Supreme Court of India. And then I will build on my arguments from there. Then I will talk about various aspects of that, how through various judgments, whether it is the S.R. Bommai judgment or whether it is the judgment of the court that was given in the Kyoto Lohan case or Minerva Mills case, this doctrine of basic structure has been built by Bagh. अब कैसे example दूंगा, तो एक बार अब ये मैंने लिख दिया. Then I come to the other side of the scholars. Let's say I gave you the example of someone like Krishna Swami mentioning about role of Supreme Court, role of judiciary in evolution of doctrine of basic structure. एक बार मैंने ये लिखा है अब. Now I need to go into specifics of how this was done. So, for example, Minerva Mills case. Supreme Court of India said that delicate balance between fundamental rights and DPSPs is a part of basic structure of Constitution of India. Is a part of basic structure of the Constitution. This should not be disturbed. Similarly, In SR Bommai case, the Supreme Court of India is saying that secularism is a part of basic structure of the constitution, and so on and so forth. See, the idea here is not to tell you the complete answer to the question, but the idea is to tell you how we flow from Constituent Assembly debates to the views of a scholar like Granville Austin, to Madhav Khosla, to a Krishna Swamy, to a Pratap Banu Mehta, then to bringing some knowledge of the cases that we have, and then finally moving on to giving some conclusion on this particular topic. That's the difference between a PSIR and a polity answer. That's all. पॉलिटी के अंदर अगर मैं यही सेम चीजें सब लिखता तो मैं बस इसको सिंपली ऊपर ऊपर से बस शॉर्ट के अंदर ब्रीफ के अंदर लिखते हुए चले जाता पॉइंट वाइज, दैट नो इट इज नॉट इम्प्लिसिट, इट इज इम्प्लिसिट, 4-5 पॉइंट उसके, 4-5 पॉइंट इसके. यहां पे मुझे सब्सटैंशिएट करना पड़ेगा. आई विल हैव टू सब्सटैंशिएट नॉट ओनली विद द व्यूज ऑफ द स्कॉलर्स, बहुत सारे स्कॉलर्स नहीं, limited number of scholars. I'll have to substantiate that with the help of what I know from the current affairs, what I know from the judgments of the court. If I've done that, I've done my job, and that kind of an answer will fetch me maybe even 10, 12 out of 15 also. That's the beauty of an optional. Even though we have not been witnessing such high scores in optional in the last few years, but if you adopt this kind of an approach, you will be able to do something. Anyway, so I hope that you get a hang of what exactly as an optional PSIR demands from UP. ना तो अभी जैसे हमने ये जजमेंट ऑफ सुप्रीम कोर्ट की बात करी इन पाकिस्तान, तो हम इसको भी यूज कर सकते हैं ना अपने आंसर में कि ये केवल इंडिया के कॉन्स्टिट्यूशन की बात नहीं है. दिस इज अ पार्ट ऑफ jurisprudence that has evolved all across the world and which helped in getting this doctrine as a part of Indian constitutional interpretation as well. So, GS style answer क्या होगा? Basic structure doctrine given by Supreme Court, this and that and everything. Average PSI answer, उसमें मैंने कुछ court judgments डाल दी, कुछ एक आधा views डाल दिए, but a truly good answer of PSIR would require these things. What is my position? I have to state it immediately at the first go. मैंने क्या किया? I said that this is partially correct but still incomplete. Then I will use the scholar's view, 1, 2, 3, whatever. I will bring in the scholar's view to drive home my point. I need to bring in some cases, not full list of cases. 10 cases नहीं लिखने हैं, but certain cases. केशवानंदा भारती जजमेंट से ही मैं कुछ एक दो आस्पेक्ट जो किसी एक जज ने लिखा हो, जैसे मैंने अभी एग्जाम्पल दिया आपको जस्टिस वाई चंद्रचूड़ का, अगर मैं डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर को क्रिटिसिज्म पे ऊपर जा रहा हूं, आई विल यूज हिज पर्सपेक्टिव ऑन दैट. Some counter perspective to be given, and then what has been the judgments that have been given by the court in order to resolve the conflict, and then finally PSIR answers. I can't be doing fence setting. I have to be clear, I have to be precise with what is the view or the opinion that I have on the basis of the arguments that I have made in my answer. So a topper answer, as I said, the statement is partly true. Yes, the constitution did carry an implicit commitment to inviolable features, but it is not the full picture. The court has not merely identified the doctrine, the court has actively shaped it case by case for 50 years. Granville Austin, in working of a democratic constitution, frames the Indian constitution as a structure of accommodation where the framers built it as checks against amendment based destruction without textually spelling out what those checks were. Once I have done that, then I bring in a certain case law, Keshwananda Bharati case, Minerva Mills case, NJAC, electoral bonds, etc. Then I bring this as a real life example from the recent times, something like the NJAC case. And then finally, I go on to give a counter perspective, how the judiciary has tried to resolve this particular issue with the help of its judgment, and that's how the answer is going to be differing from GS. Right? So the point that I'm basically trying to make is that the difference between PSIR and polity is only this much. But that is easier said than done. It requires a lot of effort, it requires a lot of groundwork to be done by you, and of course it requires extensive amount of reading and practice as well. आप सिंपली जीएस स्टाइल जो है बस ऊपर ऊपर से चीजें लिख कर नहीं आ सकते और एक्सपेक्ट नहीं कर सकते कि आपको जो है 270 280 नंबर मिल जाएंगे पीएसआईआर के अंदर। इस साल भी स्टूडेंट्स लाए हैं, लाने वाले देखिए 280 300 भी लाए हैं पीएसआईआर के अंदर। देयर आर स्टूडेंट्स हु गॉट 280 290 एज वेल, बट स्कोर्स हैव डिप्ड बिकॉज व्हाट इज हैपनिंग इज पीपल आर थिंकिंग कि अरे ये तो जीएस जैसा ही है, इसी के अंदर वैसा ही जीएस जैसा ही आंसर लिख देते हैं, यू विल नॉट गेट मार्क्स। इफ यू हैव टू ट्रूली get 270 plus 280 plus so that you have some margin to have some kind of scope for things going wrong in GS as well, because optional के साथ देखिए अच्छी बात ये है कि अगर आपका ढंग से prepared है and if you have practiced well you can be certain of good marks. GS the problem is that question कहीं से भी कैसा भी उठा के पूछ सकता है वो, and there can be certain kind of variation in GS. You can overcome that variation in GS if you have your optional solid in place. Anyway, so that's what we need to keep in mind. What are the sources, books, etc. that we need to read as far as this particular portion of PSIR is concerned, which I am going to be taking? One, Granville Austin, Indian Constitution, Cornerstone of a Nation. Okay, so this is the book which is there. Again, you don't need to read it cover to cover. There are certain chapters of this book that are supposed to be read. I'll be telling those to you. Second is Granville Austin has another book, Working of a Democratic Constitution. So this is more about the experience of the functioning of the Indian Constitution over the last 70 years or so. Of course, this book was written back in the day, but this still remains to be a very relevant book. For another topic which is very important in our syllabus related to public institutions, statutory institutions, regulatory institutions, etc., we need to refer this Devesh Kapoor and Pratap Bhanu Mehta's Public Institutions in India. Okay, so again ये किताब भी पूरा कवर टू कवर पढ़ने की जरूरत नहीं है. There are जो हमने अभी सिलेबस देखा था 11 टॉपिक्स देखे थे, उसमें जो टॉपिक 4 and 6 है, for those topics you require this particular book. Okay, so how Indian institutions exactly work, judiciary, police, administration, regulatory institutions, statutory institutions, etc. Then another very important topic of our syllabus is federalism. There is a very short thin book. Oxford की ये एक short introductions की series आती है, तो बहुत ही पतली सी किताब है, मेरे ख्याल से तकरीबन 125 पेज की होगी, इतनी छोटी सी किताब है बस. That book which has been written by Louis Tillin, that book also has to be referred. ये cover to cover पढ़नी पड़ेगी आपको, और ये बहुत ज़्यादा है भी नहीं, मतलब मेरे ख्याल से अगर आप if you are someone who is able to get a grasp of concepts in political science, it will require possibly maybe 2 days to cover this entire book cover to cover. Okay, then what are the other books? Okay, there is another book which has been written by Madhav Khosla, India's founding movement. Again, no need to read the complete book. इसके first 2 chapters और introduction अगर हम पढ़ लेंगे तो we should be good enough to understand the idea of democracy, how democracy was born in India, what were the debates that were taking place at that point of time, etc., and so on and so forth. And then there is another book which has been written by Nirja Gopal, which is called as Democracy and State. Again, helps us in building a good understanding of the relationship between the state and democracy, and the debate and between the citizens and the state, and the powers of the state and the rights of the citizens, etc., and so on and so forth. Apart from this, there are some other sources also that you would need to refer. Again, not cover to cover, but certain specific things need to be covered from those sources as well. Debates of Constituent Assembly of India. What are the specific portions of the debates that we need to refer? I will tell you. Okay, that hard work would be done by us. Second, Punchi Commission report, the second Center State Relation Commission report on various tensions that exist in India's federal functioning. Third, at times we may also need to refer some of the judgments of the Supreme Court of India as well. Newspaper reading with some amount of editorial analysis should be enough on that front, but if there is anything else that would be required for specific recent judgments, I will let you know. Sarkariya Commission report. Again, some basics related to center-state relations in India. We will have to have some perspective on that. Again, cover to cover नहीं पढ़ना है, specific portions क्या पढ़ने हैं एक तो मैं आपको बता दूंगा, and secondly we will also take extracts from these reports, make a compilation, share it with you so that you people can read it from there. And then ARC2, इसके अंदर भी कुछ specific reports हमें देखनी होंगी. Conflict resolution की report है, local government के ऊपर report है, those reports we will have to have a look at, and then we will have to keep a lookout on PRS website as well for any new bills, any new changes that are coming in the law in India. As far as newspapers are concerned, I would say that reading Hindu and Indian Express editorials should be enough. Only editorials. I am not talking about that you should only read editorials for preparation of the exam, but आप exam preparation के लिए वैसे भी editorials और newspaper पूरा पढ़ेंगे ही. Specifically कोई जो editorial constitution से related आए, electoral bond, governor state relationship, federalism से related, अगर कोई भी ऐसा topic के ऊपर कोई newspaper के अंदर editorial आता है, especially by a prominent scholar, maybe someone like the Chakshu Roy from PRS, could be someone like Pratap Bhanu Mehta, could be a retired professor of JNU or something like that. Someone of that stature who has written an article, that becomes important for us to understand things. And of course, for other topics, other faculty will tell you that, let's say, you must give importance to articles written by C. Raja Mohan when it comes to international relations. Right? If you have to understand something related to the social movement, then you must read articles by so-and-so author, etc. and so forth. So that is another thing. And then another important source that again you should refer is EPW, Economic and the Political Weekly. Again, उसके अंदर सब कुछ नहीं पढ़ना है. Some specific articles that will keep coming from time to time, we will tell you while our classes are going on, and we'll try that every couple of months we give you some compilation of certain articles as well, which you can use for your reference and understanding, where you can use certain things from those in your answers. Again, अब आप बोलेंगे कि तो सारा कुछ बता दिया, right? The point is that optional, मैं बार बार आपको बोल रहा हूँ कि आपको एक बार तैयार करना है, उसके अंदर बस कुछ चीजें वैल्यू ऐड करनी है अपनी. वंस दैट इज डन, देन ऑप्शनल उतना डायनेमिक नहीं है जितना आपका जीएस डायनेमिक है. एक बार आपने उसको ढंग से प्रिपेयर कर लिया, आप थोड़ा बहुत न्यूज़पेपर्स पढ़ते हैं, पर्सपेक्टिव्स हैं आपको, तो आप ऑप्शनल के साथ डील कर लेंगे. जीएस में ज्यादा उस तरीके से तैयारी लगती है, एंड देन यू डोंट इवन नो व्हाट द रिटर्न ऑन इन्वेस्टमेंट इन टर्म्स ऑफ योर टाइम इज गोइंग टू बी, राइट? सो न्यूज़पेपर्स, आई हैव ऑलरेडी टोल्ड यू that you need to be looking at Indian Express and Hindu opinion articles, especially from some of the prominent scholars, experts, and weekly, monthly, you should look at some of the articles from EPW kind of magazines as well. Frontline, etc. भी देख सकते हैं, but I think EPW is more suited to something like the PSIR as an optional. Okay, so for the topics that I will be taking as a part of the PSIR optional, there will be around about 20 to 24 classes, right? And the classes will be almost 150 minutes each. I have mentioned 2 classes per week here, but I mean, I'm saying 2 classes per week considering that if my classes are going to span over a particular period of time. It's not that my classes are all going to be in one go, because what I am going to teach you is also going to be dependent on what the other teachers are going to teach. So we will need to go mix and match kind of an approach as well. And this is what broadly the class plan would look like. Like we'll spend like on topic 2 and 3 on making of constitution salient features, possibly around 8 classes. Principles, organs of union and state around 4 to 5 classes. On grassroots democracy, statutory, regulatory institutions around 5 to 6 classes. Federalism as a topic, you will be spending around 3 to 4 classes. And then planning, economic development, we would be spending around 2 to 3 classes. Okay, that's what the breakup is going to be largely. When the course is going to start, etc., and all of those things, those details can be obtained from the administrative staff here at Vision IAS. I don't really have much knowledge on that for now. Why PSIR? Why now? I think the answer should be amply clear to all of you by now. One, it has been one of the most consistent scoring optional in the UPSC examination. Yes, there has been a slight dip in results in the last year, but you must also understand that that variation keeps happening in all the optionals year to year. इस बार anthropology का भी ऐसा कोई बहुत ऐसा फोड़ू result नहीं आया है. The point I am basically trying to make is, and this is not to compare to any optional. Sociology का भी ऊपर नीचे होता है, anthropology का भी ऊपर नीचे होता है, geography का भी ऊपर नीचे होता है. Geography का कुछ ज़्यादा ही नीचे चल रहा है पिछले कुछ सालों से, for reasons which are unknown to us. PubAd also, unfortunately, very good optional, but again, the results have been quite average. But PSIR is one optional which has consistently performed well, and then it has a deep overlap with GS. I already explained to you. Plus, if you have good grasp over polity, this is one subject that you will enjoy, and this is one subject that you will be easily able to overcome as far as the other this thing is concerned. Okay, so that is all there from my end as far as this session is concerned. And yeah, and if there are other details, etc., I'll keep sharing them. Again, I promise that every time that I will keep my Telegram channel active. I don't, but as and when whether I get any kind of things that I have to share, I'll share it up there as well. Okay. Yes, if you have any questions, any doubts, you may please ask right now. Otherwise, we can wrap up the session. No questions? Okay, fine. Thank you so much. Have a good day.